seated comfortably. Right, Lady Dale, who is right behind there, my lords, ladies and gentlemen, our distinguished speaker tonight, who I think needs very little or no introduction at all, Shami Chakrabati, is going to entertain us this evening. I'm sure she will. The subject of her lecture, which is in memory of Sir William Dale. Lady Dale is here, as I just mentioned to you. It's an evening that we have cherished for the last few years. The first Sir William Dale lecture, memorial lecture, was delivered, I think, some 6 or 7 years or so ago. And our first lecturer, who some of you here would know, Dame Rosalind Higgins, who is a judge of the International Court of Justice. Now, this lecture is something that we treasure so much because Sir William, who, after whom the Sir William Dale Center for Legislative Studies is named, is a fixture in the legal history of the United Kingdom. Now, I'm not going to go into a long speech about Sir William, but he gave the Institute, where we are, and the Center, peculiar standing in the legal world. Sir William died at the ripe young age of 93, I believe, or thereabouts, and he was going right until the end. Some of you here will know him, but if you don't, no problem, because we treasure Sir William, which is why we instituted this annual lecture. And I'd like to welcome all of you here this evening. Now, Shami, who is our lecturer, has been director of Liberty. Some of you here may be members of Liberty. I am myself a member. She has been director since 2003. Well, she got there 2 years earlier as a counsel for Liberty, and within a matter of 2 years, which by any account I would call a meteoric rise, she became the director of the center. I'm sure some of you here know her. At least some of you here will know who she is. So I won't go into any long detail of what she does, what she has done, and what she continues to do. During the 5 years that she was at the Home Office, Shami did a lot of things. She participated in policy making in the areas of legislation, in areas of litigation, particularly with regard to terror suspects, with regard to asylum matters, with regards to personal freedoms and everything that goes with human rights. As a result of that, you might say that she had a first-hand, as a result of her time at the Home Office, where many of the things that are happening today have become a matter of concern to a lot of people, including terrorism issues, including things like the introduction of identity cards, the national identity card, which we believe is either being shelved or has been forgotten, to the joy of a lot of people, including, I dare say, herself, because she fought against it, and I would like to think that it was as a result of some of her criticisms of many of the things that happened in that area that has contributed to what we now hear that the identity card issue has become a dead issue. Now, Shami is a CBE. Now, when she was made a CBE by Her Majesty, she is reported to have said, I hope it will send a timely signal that democratic dissent is not disloyalty. It is a positive civic duty. This is an official royal invitation to do more. And I will take that invitation on behalf of people punished without trial and barred from protest in Parliament Square. A lot of the work that she has done at Liberty has involved the organization's engagement with war on terror, the war on terror that is still persisting, and in the defense and promotion of human rights. Whenever there is a march, especially the marches that go on in Parliament Square, at the heart of the constitution of this country, issues have been raised about why these people make a nuisance of themselves. Shami is not ashamed of making a nuisance of herself when it comes to matters of that nature. And she is quite a formidable person, so formidable that I don't think anybody would want to have her as an opponent. So she is quite a character. Now, those of you who listen to Desert Island Discs, which I do on the odd occasion, will know that when she was asked what book she would take with her, in addition to the other books that are provided, like Shakespeare's volumes and the Holy Bible, or the Quran, as the case may be, which may well be the equivalent, she said she would take To Kill a Mockingbird. I believe that many of you here would have read that book, and it tells you something about what she feels about people who suffer injustice, which the main character in that book suffered, but had somebody who was prepared to go to any length to go and defend that person, which is what Shami nearly always does. Ladies and gentlemen, without further ado, I give you Shami.
Thank you very much for that kind introduction that felt at times like a list of previous convictions. And there's something about being in a sort of subterranean, windowless room that gives that feeling of the interrogation room as well. I spent a lot of my life in windowless subterranean rooms, including my room at Liberty, and I like the cinema, so I'm actually more comfortable in this kind of environment than lots of other people. It's a great pleasure to be back at the Institute, and a very daunting honour to give this lecture in Sir William Dale's name, not least with Lady Dale present. You've heard the list of some of the very eminent previous speakers in this series, and I do hesitate to follow them. I am, as director of Liberty, I'm really a campaigner now, which makes me, to some extent, a lawyer in recovery, or at least in partial remission. There are litigators at Liberty who routinely scrutinise legislation in the courts, and there are brilliant young policy lawyers at Liberty who actually do the day-to-day engagement with the legislative process. I'm the director. I've had to some extent de-skill as a lawyer, but I just could not resist the opportunity to talk about a process that has been such a central feature of my career. I'd also like to say that I think the work of the Centre is incredibly important. I think that the process of legislative policy and drafting is incredibly important in any democracy, and the art and ethics of legislation are really not studied or promoted enough. And that's one of the reasons why, even though I've been to the Institute quite recently, I couldn't resist the temptation to come back. My engagement with the legislative process probably began to some extent as a law student and a pupil barrister, always with a predominant interest in public law, with constitutional and administrative law, and so much of the law that one studies in that discipline is the study of seminal litigation, which has turned, of course, on the interpretation of statutes. Some of those statutes inevitably contentious from the beginning, other seminal litigation that just arises, if you like, from an unintended consequence to which we can return. My second major engagement with the process, and possibly the most formative or even relevant for the purposes of this evening's discussion, relates to the 5.5 years that I spent in the Dark Tower. That's how we affectionately call the Ministry of the Interior or the Home Department. And I want to say that, contrary to certain media reports, I had a very, very happy and interesting time in the Home Office. I learnt, for the most part, my human rights law there, and learnt so much about the nexus between law and policy and legislation from government lawyers, from senior mandarins, if you like, and relevant to tonight's discussion from parliamentary draftsmen, who are really quite amazing people. And I had the pleasure to work with a number of them, because and this is a telling point in itself. In the 5.5 years that I spent at the Home Office, I worked on over a dozen Acts of Parliament, which I think is rather telling in itself, and that means with a large number of parliamentary counsel, incredibly clever people who have to familiarise themselves with the policy and the relevant law in all sorts of different disciplines, and try to turn often and increasingly, I'm afraid, quite rushed and ill thought out policy into something that could be vaguely coherent on the statute book. In my day, at least, I hope this is continued. They were a bit like the Jedi, and they always travelled in pairs, a master and an apprentice. And you had to be I think you had to work there for at least 10 years before they'd let you carry a pencil. And then after a little longer, they'd let you sharpen the pencil and possibly look up the relevant volume of Halsbury's for your master. I suppose the internet has probably lessened the ceremony of that process, but I joke, but only slightly, because that kind of ritual and some of the rituals around the whole practice of moving from political idea to the statute book are actually incredibly important. Slowing it down is incredibly important, because it's in that time and space that the greater thought and subsequently scrutiny comes. My third engagement with the legislative process is, of course, as a lawyer, and then subsequently as a director of Liberty, now in its 75th year. And of course, even a slight reflection on Liberty's history will demonstrate the extent to which it's always had to engage with legislation, from its birth as government announcement to its publication and through its parliamentary passage to ultimate application and inevitably subsequent litigious contest in the courts. I think at this time I would say that it's never perhaps that legislation has never been perhaps so political and politicised, in particular where it touches upon fundamental rights and freedoms more generally. And therefore some kind of discussion about the art, the ethics and the wider public understanding of legislation and the process of formulating it is incredibly important. Now, I've titled this talk Repentance at Leisure, which is something that's normally said about marriage, but I think it can be said even more strongly about legislation, the politics of legislation and the law of unintended consequence. Now, my sentiment probably speaks for itself. My general view of this process is that when things go wrong, generally speaking, not always, it tends to be more cock-up than conspiracy. But nonetheless, that's not a get-out-of-jail card for those who have been responsible for putting a lot of bad legislation on the statute book with increasing frequency in recent years. And I'm not blaming the draftsman. I'm not shooting the messenger honest. It's something to do with the sheer pressure that comes from this politics, and the consequences follow. And that's really what I'm trying to suggest in this talk. I suppose the first proposition to the politics of legislation is, why so much? Now that's something that everybody says, why so much? My Liberty colleagues estimate that there's an approximate average of 2,500 pages of primary legislation that were passed between 1990 and 1999. You can probably do your own calculation if you're very sad and have nothing better to do of an evening. And 3,200 pages on average per annum between 2000 and 2006. That's primary legislation, acts of Parliament. That isn't the oceans of statutory instruments and orders and regulations and so on. Now that is a lot of statute law. And that's not just a lot to draft for the people in Parliamentary Council's office. That's a lot of legislative policy that's supposed to be formulated, interrogated and scrutinised before traditionally Parliamentary Council are even instructed. Though that process has been, I would argue, concertinaed a great deal in recent years. Now, you can contrast that approximate figure with about 750 pages of primary legislation in 1950, and we think maybe about 2,000 pages in 1975, where you get a kind of spike. Now, how do we explain this? I suppose you could argue that the modern welfare state and regulating it and giving people benefits and entitlements and all sorts of good post-war things is going to require some legislation. So that's fine. But is that really what all of these thousands and thousands of pages are about? Well, not in the Home Office, they're not. So not the hundreds of pages that I worked on. A lot of that was really about regulating private life, not about regulating the benefits and entitlements and responsibilities of the empowering post-war welfare state. And I think that really needs to be considered. So why is it that politicians and governments feel the need to just churn out so much of this stuff? I guess some people would say that power, traditional governmental power, has migrated, or traditional power in the land has migrated either to multinational companies or international institutions, and governments and parliamentarians are just looking for something to do. I guess that's possible. I think others would say that the power and intensity of modern media scrutiny is constantly inviting some kind of response to events or to concerns, and I think there really is probably something in that. And not for the first time, I'll say that I think that legislation has become a kind of cheap, quick, and addictive drug. Quite literally. I don't know what Professor Nutt would say about this, but I don't know where on the list of dangerous substances would you put legislation, and criminal justice legislation in particular? I don't know, above or below alcohol, or above and below cannabis. But it has become a kind of drug of choice, and I think that criminal justice legislation, perhaps anti-terror legislation in particular, that's the super drug. That's the macho super drug for the really full-on tough guy politician. More generally and seriously, I think that in a whole host of statutes, not just coming out of the Home Department and the Ministry of Justice, you can chart the rise of the criminal sanction as the lever of first resort. Governments are trying to change people's behaviour or affect people's behaviour in a whole host of areas, health and safety or metrication or all sorts of things, possibly perfectly laudable. How often do we see the criminal sanction as the lever of first resort? Think about the alternative possibilities. You could start with mere exhortation at the one hand. The government would urge people to do X. That's a start, isn't it? And then maybe some education, some public information and education. That would be a possible lever to try and affect behaviour, perhaps. And then maybe an incentive. How about that? Maybe a positive financial incentive to do something that the government thinks is a good, beneficial, social good thing to do, and then possibly moving into a slightly more punitive way of affecting behaviour with some kind of regulatory regime, some kind of civil lever or sanction, with ideally, in my view, predictably in my view, leaving the criminal sanction and the imprisonable criminal sanction really as the lever of last resort, so that it means something, so it isn't discredited. But I'm sorry to say that if you look across the statute book, not just in the world of home affairs or criminal justice, you will see these criminal sanctions being churned out more and more. And the other thing that you have to say when discussing the politics of legislation is the point about knee-jerk immediate responses to concerns or crises. And I suppose there's so many examples of this. Dangerous dogs kind of bore me. I'm not really an animal lover, so and it's a bit hackneyed now to talk about dangerous dogs. So why not talk about loutish behaviour? I wonder if you remember the former Prime Minister, and some would say putative President of Europe now, Mr. Blair, who stunned students in Germany in the summer of 2000 when he said he'd had enough of young louts with their foul mouths, uttering expletives into the night air, and really what ought to happen is they ought to be marched to a cash point for an immediate, off to the cash point, and out comes the cash on the spot. Instant justice. Great idea until the poor old officials, one might imagine, start thinking, how exactly is that? Forget the kind of legal human rights sort of due process issues of that. This is a drunken lout. You're going to march them to the cash point when they're drunk in the middle of the night, and they're going to say, "Excuse me, sir, would you type your PIN number into the cash point?" And of course they're going to do it, aren't they? And out will come the £100. Anyway, mercifully, there were sensible officials working in that department who were quick of wit and sound of mind, and mercifully, that particular wonderful bit of spin got sort of transmogrified into a metaphor for fixed penalty notices for loutish behaviour, which actually weren't that desperately outrageous and authoritarian, because all they do is they give you the opportunity to buy your way out of going to court. Like with a driving matter, where you can go to court if you want to, or you can pay your way out. But a very interesting exercise in almost instant legislation. Prime Minister has a great idea, tough speech in a foreign land, and people in Whitehall have to run around like headless chickens inventing metaphors and drafting legislation, which actually might not have been that bad in the end, but it's a funny old way to do business. And then we get into the really serious stuff, emergency legislation. Now, I think there's been so much emergency legislation that in recent years that one really has to begin to unpack what we mean by emergency and what we mean by emergency legislation. I've said many times before, you're probably bored of me saying this, that I think that an emergency has to be something truly different from the norm. If we're all told that we are living in a very, very dangerous world all the time, well, that is not an emergency. Right? We probably are living, for all I know, in a very, very dangerous world all the time, but that is not an emergency. In the English language, an emergency has got to denote a departure from the norm. An emergency legislation that requires swift parliamentary passage and exceptional interference with individual rights and freedoms has got to be justified by something that is a grave departure from the norm. Now, we understand that in democracies where different limbs of the constitution play their respective parts, for the most part, the executive has that discretion of choosing when that moment comes, to press the button and say, now as a state of exception, we've seen the secret intelligence, you haven't. But, you cry wolf too often and you lose trust in the executive, in politics, in the institutions of the state. Now, The Twin Towers atrocity was an atrocity. It was a gross violation of human rights. But did it really create a state of emergency in the United Kingdom that justified internment under the Anti-Terrorism, Crime and Security Act of 2001? The House of Lords did not want to go there. House of Lords, as was, did not want to go there when they eventually impugned Part 4 of the Anti-Terrorism Act of that year. They dealt, as you will remember, with the relevant provisions by way of discrimination principles, because of the illogic of locking up foreign nationals indefinitely on the basis of suspicion when British nationals who were suspected walked free. And of course that discrimination judgment, based on the illogic of that proposition, was tragically borne out by events in 2005, when this country was attacked by, this capital was attacked by suicide bombers who were British, who would never have been capable of detention under the 2001 Act. But I do still wonder whether that was truly, for all the terrible things that have happened, whether you could really say that that is something akin to a war or other public emergency threatening the life of the nation as intended by Article 15 of the Convention on Human Rights. I think a conventional war and a cataclysmic moment in a conventional war is different from metaphysical wars and difficult times, however long-standing. Constitutionally different, because if you're asking people to enter into an undefined, permanent, long-term state of emergency, that is not a state of emergency at all. That is a new normal, to quote Donald Rumsfeld. The long war, the new normal. And how will we, the people, know that the war is over? Presumably we wait for Hillary Clinton the 52nd or George Bush the 83rd to say one more push, guys, and the war on terror is over. So I don't think that we should allow governments to say there's a state of emergency because we're living in dangerous, difficult times. There are all sorts of consequences that come from them being too casual about that kind of legislation. And look at what followed. Control orders in 2005, terrorism acts of 2006 and 2008, what's still under this emergency? Every time a new atrocity happens, does that denote a new emergency? I don't think so. Not necessarily. But what it does seem to invite is a new legislative response. Even if, as in 2001, a large, comprehensive piece of consolidating terrorism legislation had literally just been brought into force. That's the politics of knee-jerk legislation. Another aspect of this kind of phenomenon is the way that routine powers are dressed up as exceptional reserve powers. And that's something that we noticed during our recent campaign against 42-day pre-charge detention at Liberty last year. When it became apparent that the government was really onto a sticky wicket with the basic argument for locking up suspects for 42 days or 6 weeks or 1,000 hours in a police station without charge, without knowing why. Not pre-trial, not as people often are, for a year or two pending trial while you prepare your defence, but pre-charge. You don't really know why you're looked up. The case started collapsing. The government began to dress up its legislation with this drafting device of calling this an exceptional reserve power, triggered by a grave terrorist threat. But when you looked at how a grave terrorist threat was defined in the draft legislation, this was a test that could be met in any case, in any individual case where there was an operational need to lock the person up for longer. So the exceptional, so the routine dressed up as the exceptional. A drafting trick, if you like, but clearly politically motivated in order to help the passage of very difficult legislation. Deliberate complexity, selling something politically as something quite different indeed. And another trick. It's like giving the manual to the. I hope everyone here is on the side of the angels, because if not, I'm going to give you all sorts of. If they're government lawyers here, you're going to hear it all now. How to pass draconian legislation and get away with it. Another obvious sort of little parliamentary trick, little political trick, is what I call Plan A, Plan B, where you prepare your difficult, contentious legislation with concessions already in mind. So you've got a little back pocket, second string. I see a few people nodding. They must be government lawyers. They've been there before. So 90 days is where you start, but you're prepared to, get a 60 or 40 or maybe 28. And then 28 is supposed to make me feel that we won. Yeah? There's kind of Dutch auction, but you can actually deliberately start a legislative process as a policymaker or a politician, knowing that you're putting some really outrageous stuff in that you can compromise on, and aren't you so reasonable because you heard concerns and you met with those civil liberty campaigners and those rebel backbenchers and so on. And another element of that, of course, is the friendly rebel. This is a backbench member of Parliament usually, rather than a peer. They do things differently. The House of Lords is another country. They do things, I'm glad to say, differently there. But in the House of Commons, you get a friendly rebel who's really not a rebel at all. Who's really on a promise for a government job at some stage or other, but is prepared to make a little bit of noise about concerns about whatever the legislation is, so that at the 11th hour, his or her amendment will be produced, which the Home Secretary or the Lord Chancellor or whoever it is able to welcome, and this friendly rebel will then hopefully lead some other members of Parliament who had concerns into the government lobby. This is all sort of dirty political stuff, but it is highly relevant to the legislative process. And those of you who have been parliamentary draftsmen or government lawyers, I'm sure, are familiar with it. Another routine feature of the politics of legislation is, of course, you're grown with the familiarity of this, the use of schedules and, in particular, regulation-making powers as great places to bury bad news. And whilst my talk's full of bad news, there is actually some good news as well, which is that the public and the media and parliamentarians are waking up to this, and I think feeling less and less inclined to go along with this little trick. Two bits of evidence for that. I think the Coroners and Justice Bill, that's still kind of wending its way through Parliament, it's in the House of Lords at the moment, originally contained a breathtaking order-making power in relation to sharing data between government departments with private persons. It was an order-making power by which a minister could have basically amended any primary act of Parliament, any rule of law, including the common law, to share anybody's data with anyone, if it was in the public interest. Sweeping order-making power, and mercifully ultimately withdrawn because of public clamour and media scrutiny and parliamentary dissent. So that's one for the good guys. And more recently, in the Policing and Crime Bill, which is again currently going through Parliament, the government thought it would respond to last year's Court of Human Rights judgment in the case of S and Marper, which is about DNA retention. It's about us having the biggest DNA database full of innocent people and children and so on. Biggest database in the world. Impugned that existing policy by the Court of Human Rights, and the government thought it would respond by way of putting a regulation-making power into the Policing and Crime Bill. Now, this is really interesting, because this is a bit like saying that maybe it's an emergency because we lost a court case. No, seriously, that happens sometimes, both in relation to saying we need an order-making power suddenly to be snuck into a bill that's currently going through Parliament, or we actually need a primary act of Parliament to be rushed through in 2 days. Witness anonymity bill last year, because we lost in the House of Lords. We did something, the House of Lords said it's wrong, so emergency. Just like a terrorist atrocity, a law lord's ruling, legislate in a hurry. Anyway, so the government thought it would deal with this highly contentious issue of the appropriate balance between personal privacy in relation to your DNA and the laudable necessary purposes to which DNA is put in the criminal justice system. This was going to be dealt with by regulations at a later date. Now, I have to say, thinking that you can get away with that makes you someone not who needs your DNA tested, but your head tested. And sure enough, Mr. Johnson, the new Home Secretary, did not need his head tested, and very sensibly withdrew that proposition. Interestingly, the government knew what it wanted to put in the regulations. The government had already announced its views on a consultation, and the plan was, we're going to keep your DNA if you've been arrested of anything for either 6 years or 12 years, depending on what you were suspected of. They were pretty clear about the intention. So why regulations? Why not put it on the face of the bill? Argue it out in Parliament, where parliamentarians can engage in debate, have lengthy scrutiny, table amendments, and so on. Interesting. Regulations, pass in a hurry, yes or no, put the parliamentarian in the position of having to make this cataclysmic choice. No DNA retention at all if you vote against the regulations or go with what the government's proposing. One of the many, many problems with making contentious law that way. And then, of course, you could argue the mother of all regulation-making powers is in the famous Civil Contingencies Act of 2004 that really would be the end of the world as we know it if it were ever actually invoked. So let's not dwell on that. Moving to the law of unintended consequence then. You've got all these brilliant political motives like looking tough on terror and responding to your own illegality in a House of Lords judgment, and you've passed all this very good law. But maybe you didn't quite get it right on the journey from the bright policy idea to the statute book. The law of unintended consequence then kicks in. I think an obvious example of this would be, or an obvious category of this type of case would be what we call overbreadth, where a power was drafted for actually perfectly sensible reasons, but it's just overbroad in what it covers, and consequentially doesn't have sufficient safeguards, precision, etc., etc. I think one obvious example would be Section 44 of the Terrorism Act of 2000. Now, for those of you unfamiliar with this provision, this is the anti-terror stop and search power that allows people to be stopped in certain circumstances without reasonable suspicion of any criminality. And the power is triggered when a chief constable, or in London the Met Commissioner, thinks it's expedient to preventing terrorism. Expedient, right? Not necessary, not essential, not proportionate, but expedient. And this is an example of another kind of very fashionable legislative trick, which is effectively sub-delegating legislative decision-making to an administrative or executive person. Could be the minister, but increasingly could be a chief constable or someone like that. And the chief constable thinks that we need stop and search without suspicion in a particular area, and he turns on the power. And now the normal law of the land in relation to police powers and stop and search, which as you know is triggered by reasonable suspicion, has been turned off and replaced in the area, by the way, not defined in the statute, right? Overbreadth, lack of precision. in the area, the moment the chief constable turns on this power, you can stop and search people without suspicion of any criminality because it's expedient to preventing acts of terrorism. Now, I will concede that a power like that may actually have a laudable purpose. I can think of one right now. The normal paradigm of stop and search with reasonable suspicion is fine in a situation where I see somebody and I think they're behaving suspiciously and I think they might be about to do something, I want to prevent it, I stop and search them. But what if it's the day of the Queen's speech, day of the opening of Parliament, I've got intelligence of a possible threat, and there are just people everywhere and I do not know who the suspect is? I will concede, as someone who subjects myself routinely when I enter Parliament on an almost daily basis, or when I go to the airport or whatever, there are circumstances where it might be proportionate to ask people to be stopped and searched politely and without offence. Now, why is it that that's okay? I think it's okay because when I enter Parliament or when I get on a plane, I can see that it might be proportionate to do a bag search and an out-of-body search, so I don't complain. I can see the proportionality of doing it. I can see the case has been made. Secondly, everybody's treated the same. I'm not being singled out because I'm a protester or because of my race or because of any factor like that. Everybody's been treated the same. It seems to me that if there are situations like that that arise, special events like the opening of Parliament or special bits of intelligence, there is an argument. There is an argument for the ability to have ring-fenced stop and search without suspicion for everybody without singling certain people out. However, as I say, legislative disaster, no safeguards, overbreadth, and what happens? This is the power, perhaps more than any other, that's been routinely used against peace protesters, whether at the Excel Centre in London or poor old Walter Wolfgang, who was famously carted out of the Labour Party conference. So an excellent example, I think, of something going wrong between intention and execution on the statute book. Again, I'm sure it wasn't the drafters, but just a lack of care in the policy development and a casual approach to this kind of law on the part of ministers. REPA, the Regulation of Investigatory Powers Act, perhaps you're familiar with. Some popular newspapers now call it the Snoopers Charter. It was actually originally designed as a piece of human rights safeguarding legislation to regulate intrusive powers that were previously largely unregulated in English law. What did the present Lord Chancellor, former Home Secretary, say about it when it was going through Parliament 9 years ago? He was talking about the various powers of intruding on people's privacy for criminal investigation purposes. Drug trafficking is just one example, he said. Some of the powers underpin vital national security operations. They're also key to tackling the serious and organised criminals involved in money laundering, human trafficking, paedophilia, always a good one, tobacco, smuggling and other serious offences. Now, it wasn't just terrorism, as is sometimes portrayed in the newspapers. It was other serious crime as well. But the powers in this Act, some of them quite intrusive, surveillance, have now been used to police school catchment areas. Now that kind of regulatory activity, in my view, is not akin to terrorism, human trafficking, paedophilia, and so on. Sold for one purpose, used for another, because the powers are just broad enough to be so used. And we learnt just earlier this week that it's being suggested that local authorities and others should be able to use confiscation powers as well. A lack of precision or safeguards, another obvious example, summary extradition. I'm sure that many of you have heard the case of Gary McKinnon. There are other cases of summary extradition, and originally intended to speed up an extradition process that I will concede had become incredibly long and convoluted, too much ministerial discretion and therefore umpteen judicial reviews, every time a minister tried to extradite a suspect to another country. Really did need streamlining, I would argue. But instead of just taking the discretion from the executive to the judiciary where it probably belonged, not just our extradition agreement with the United States, but the Extradition Act that governs that, and now the European arrest warrant and so on, has basically taken discretion out of the process altogether. So we're parcelling people off who ought to be dealt with here, and we're passing people off who are vulnerable, passed again after 9/11, used for a hacker with Asperger's syndrome like Gary McKinnon, rather than the terrorists that we were told this was all about. So that's the kind of overbroad legislation that's kind of passed in for one purpose and used for another. There's another problem, I think, in terms of unintended consequence, and that's what we call the sort of contagion of going down a particular legislative route in one area of the law, making an exception, and then finding that exceptional legislative process spreads to other areas of law and administration. One example would be the plethora of quasi-civil orders that seem to be replacing, and which have replaced criminal justice, traditional criminal due process in our country. ASBOs and parenting orders in 1998 start, whatever you think of them, and they have been contentious, you start down a road that continues to control orders in 2005. The idea, in both cases, what is your policy problem? Your policy problem is there's someone who you suspect is up to no good or has been up to no good, but proving it is difficult. So instead of taking them through a conventional criminal justice process with the criminal standard and burden of proof, proving the person's committed an offence, you seek to obtain a civil order on a slightly lower standard of proof with lesser safeguards in the courtroom because it's a civil order. And then what you pass is a very broad and sweeping and often ill-defined injunction banning them from certain activities. And then the person walks on the cracks in the pavement and bang, it's a criminal offence. You start with ASBOs and you end up with control orders. What's the difference between an ASBO and a control order? It's kind of ASBO met SIAC. It's kind of secret national security ASBO, that's a control order. And the second would not have been possible if it weren't for the first, because you created this scheme that is then cut and paste and developed over the years, and there's a straight continuum that starts with the ASBO in 1998 and goes to the in a sense more terrifying prospect of the control order, and subsequently we've had gangster ASBOs, they're the new one, serious crime prevention orders, and violent offender orders too, but it's the same idea. Quasi-civil injunctive orders because it's too difficult to give someone the presumption of innocence and the right to a fair trial in the conventional sense. And the second part of contagion I've already alluded to is secret courts, secret tribunals. Secrecy really spreads like a contagion. It's very natural in government. It has its place, but if it's allowed to mushroom in the way that it has, we see some really quite terrifying results. A little bit of personal responsibility in this regard. I worked on the Special Immigration Appeals Commission Act of 1997 as a young government lawyer. I thought I was doing good. Doesn't matter whether I thought it or not, but I did. I thought I was doing good. The Home Office was implementing a Court of Human Rights judgment in a famous case called Chahal against the UK in 1996. People being deported on national security grounds were getting nothing. No appeal, no due process. They were getting nothing. We created this scheme that includes special advocates appointed by the Attorney General to test the case against you that you will never see in your interest. We created that scheme supposedly to give some protection to people who had nothing. And look what then happened with this idea of special advocates. Internment after 9/11, how was it dressed up and excused? There'll be special advocates. control orders. It isn't secret quasi-justice. It isn't a kangaroo court. It isn't unfair because there are special advocates. And the latest part of this process, I'm told, is that in litigation, ordinary civil litigation, brought on behalf of Binyam Mohammed, who was rendered for torture, and a number of other people in a similar position, that they're suing the security services and the government for collusion, complicity in their torture. And the government is arguing that instead of having a normal civil trial with normal rules of discovery, the court should invent, without any statutory authority, the court should invent a closed evidence procedure and appoint special advocates. Right? This isn't traditional public interest immunity where one party, the government asserts that material shouldn't be disclosed to the other side, because in that proposition the government wouldn't be able to rely on that material either. This is the government saying we can do this behind closed doors. We can shut the claimants out of this civil claim for damages for torture because we can use a closed procedure which the court can invent of its own volition, and one party can be outside the room. And that's literally how it works. I've been to proceedings that involve special advocates. One party literally sits outside the courtroom all day while government lawyers argue in court. And this is the continuum of a road that I began on as a young idealistic government lawyer in 1997. So there I am again, gloom and doom. Some good news along the way, I think. Some of these battles won, some of these outrages defeated. But nonetheless, I think lots of reason to be constantly vigilant, not just about the basic propositions of human rights and civil liberties, but to pay much closer attention to legislative detail, legislative drafting, to the ethics, as I said, the ethics and the art of legislation. And for those of you that are government lawyers and draftsmen, I think you do an incredibly important job. For those of you that aren't, there is no more important enterprise for citizens in this country at this time than to understand this process a little better. Thanks a lot.
Thank you, Shami. Our lecturer has graciously accepted to agree to take some questions. So if anybody has any questions, could you please identify yourself and fire away with your question.
I'm not a lawyer, so I can't. I just wondered if you had more answers, because I mean, obviously, I know it's not your case tonight to give answers, but in general, the complexity of, say, terrorism acts or the problems of international immigration, this kind of thing, they do necessitate, I would imagine, complex law, and therefore it's obviously, as you said, it's traditional, isn't it? I think in law for things to be shoehorned into complex bills and things. I'm thinking of Frolic Zone or something where things get. That's inevitable. Governments will always want to slightly overcomplicate things in order to put in other things they want, pass things quickly if they can, and obviously if you are having to fight with difficult enemies who you can't identify in the field of conflict, all this kind of thing, you've got to get difficult laws. What would you suggest for the lawyers in the room in terms of trying to combat that inevitable procedure of what the government is going to do, whoever's running the country?
I think I would not try to suggest that generally speaking the government is in the business of overcomplicating the law. I think there are a couple of occasions that I pointed to where you can see that there's an element of trickery in trying to make one law look a bit like another. So trying to make something that they intend to be a routine power, trying to make it look like an emergency reserve power. Okay, but generally speaking, I don't think that complexity is a direct result of I don't think Home Secretaries and Prime Ministers say let's draft a criminal justice law or an anti-terror law and let's deliberately make it complicated so that people don't understand it. I think that the complexity of the statute book or when there is law that is difficult to read or understand part of that comes from rushing the process, because it is a great art, a great and very difficult art to turn policy into law that ought to be readily understood. I mean, you can say it's a fiction that we should all be able to read the statute book, but it isn't too much of a fiction. You know, there are. I mean, I would say this, wouldn't I? But if you look at the Human Rights Act, it's really not that complicated. It's fairly short, and it's actually quite exquisitely drafted so that ordinary people can read it. But, you know, that was a project that took a very, very long time from policy gestation to delivery, and maybe it was a labour of love by the draftspeople as well. But if you're churning out a great big criminal justice bill every year, and then chucking new ideas and announcements and policies into it, it's just not going to be. It's just too much pressure on the system of policy formulation, the system of drafting, and the legislative process to expect to get something. You know, even if the policy's great, the speed and the intensity is going to make for a less good statute book. Yes.
David Boardman, a former civil servant and one who has used the techniques to get his legislation through. The last estimate I saw was that there was 100,000 pages of primary legislation. 3,000 pages a year argues something like a 30-year turnover for law on average. That's not unreasonable. I see people are talking about the Misuse of Drugs Act as being 30 years old, and perhaps we ought to be doing something about it. In practice, the statute book is schizophrenic, because perhaps as much as half of legislation is now published in draft, and that's been a project for the legislative committee and the ministers concerned with it to improve the standard of law. What you have is a mad rush for slots by ministers who want to make names for themselves, and hence you get some of the statute book, particularly criminal justice legislation, where you are putting it through at a rate of knots, perhaps 3 or 4 bills a year. There isn't enough capacity anywhere to cope with it, particularly in the Home Office. As I say, not all legislation is rushed in this way. It is particular sorts.
No, I think that's right, and I wouldn't say that. You know, I'm not some sort of ultra libertarian who thinks that you shouldn't have any legislation or that it's unnecessary. But ironically, some of the stuff that is rushed is the most contentious, and really ought to be taken the most seriously. And you know, that's inevitable. I think even in what you say, that the people making a name for themselves, or the people responding to an immediate crisis, or whatever, criminal justice, etc., etc. And you know, and those are perennial issues. I really don't see why the criminal statute book in particular requires annual top up. I really don't. And in fact, I'd like to see a bit more repeal and a bit less. Oh, it's that time again, folks. It's that, you know, with Poppy Day, run up to Christmas, the Queen's speech, and actually, do you feel sorry for the Queen sometimes, don't you? Particularly when the Queen's speech is drafted badly. We forget legislative drafting. There have been moments, because obviously I've spent most of my adult life watching the Queen's speech and madly scribbling away. I mean, it's easier now because of the internet. You can get it online very quickly. But scribbling away, both as a civil servant and at liberty, what are they announcing? But you can't help but chuckle when Her Majesty has to say things like, "Education remains my government's number one priority," and which is great and fine, and there's nothing draconian in that. But you just don't believe that she ever says number one priority as opposed to priority or anyway.
Hello, Chris Shaw. I'm a clerk in the House of Commons in the Committee Office, and I want to just test your views on post-legislative scrutiny to see if you think that this is something that could be usefully done in order to identify some of those errors and lacuna that you've identified and to put them right. The government have agreed to a proposal from select committees now to on an annual basis to go back 3-4 years to look at bits of legislation and to do a report and to see whether they are actually working or not, and the committees are being encouraged to take that. Do you see that?
I think in principle it's a great idea. I mean, in pre- and post-legislative scrutiny are in principle great ideas, but what's important is the political will. Because if you have pre-legislative scrutiny and you have umpteen select committees, Home Affairs Select Committee, Joint Committee on Human Rights, etc., or post-legislative scrutiny, and you get all these people writing really relevant, pertinent reports that then get ignored. You know what I mean? It's not going to help. So, and what it would take for post-legislative scrutiny to actually work politically, it seems to me, is an element of bipartisanship, an element of kind of, in a sense, it's a risk at the beginning. If it's done for the first time, maybe, it's a dangerous thing to say, but maybe the time to try and do it is when there's a new government, because they can risk it the first time, because almost by definition they're not having to admit to their own mistakes. It's very easy, maybe that would be a good moment, if such a moment arose, for argument's sake. That would be a good moment to try and push this, because if you then got Parliament into the habit of saying it's no big deal, it's not admitting a terrible deficiency of government or a terrible scandal just to say we do this in a democracy. We pass laws for ostensible reasons, but actually sometimes the delivery is not, and the application in practice is not quite what we thought, what we intended. Like the Section 44 example. There are other the Parliament Square protest stuff. I've seen cabinet ministers sit there on Newsnight red-faced in the face of Maya Evans, who was famously prosecuted for reading out the names of dead soldiers and dead Iraqis, and the cabinet ministers will say that should never have happened. Well, you can just blame the police and the prosecutors, and maybe sometimes you have a point, or you could say, fine, so let's go back, as you suggest, let's go back to the statute book and say, we're not saying that we were completely wrong in our intent, but the application, the delivery is not quite right, so we'll fiddle with it. Why not that rather than just saying it goes from legislation to litigation? Parliament is sovereign. Why shouldn't Parliament I think it's a great idea, but it would take that kind of political courage and will. As I say, it may be an interesting idea under a new government, but can you persuade a sitting government, particularly one that's been impugned for so long by the likes of me and others for all these bad laws, to say, oh yeah, Shami, you were right. I'd love it, but what I'm saying is these sorts of innovations require political will.
My name's Chris Humphrey. I'd like to ask you, what in your experience does work against serious organised crime or terrorism?
In my experience, and I don't claim to be an investigator or a prosecutor, but I have been a government lawyer and I have engaged with investigators and prosecutors. In the end, I do think that the traditional skills of investigators and prosecutors are what really works in the end. If you look at terrorism in particular, so Ken MacDonald and latterly Keir Starmer, but in particular Ken MacDonald, in his time as DPP, really developed and concentrated skill sets in the CPS. So you have specialist units who are the crack team and they used ostensibly, largely traditional criminal offences, traditional anti-terror offences, and in the end, that is what worked. Ken MacDonald, incidentally, is also, like me, a proponent of using intercept evidence in these trials, and that I think would be relevant to organised crime as well as terrorism. And Liberty's been advocating that for some years. Traditional. I mean, I think the thing about intercept is just balmy, frankly, because we all accept that sometimes it is legitimate and proportionate to intrude on someone's privacy. Not, in my view, for policing school catchment areas, but proportionately for serious crime like terrorism and so on. If I would like to see judges sign the warrant, as in elsewhere, but leaving that aside, if it is legitimate to intrude on somebody's privacy, I think, and you've done it, and you've taken the phone call, and you've got this incredibly useful incriminating evidence, could be exculpatory in another case, but incredibly useful, me convicting myself from my own mouth, not under compulsion, but because you've got me. Isn't it mad not to attempt to use that in a criminal trial? And of course, if instead of tapping my phone, intercepting my phone call with you, where I admitted everything and planned everything, if instead you just put a bug under my desk and heard it, that would be admissible. And equally, if it was an interception that came from a foreign government, that would be admissible. I mean, I think that anomaly really does need to be addressed, and I'm not alone in that view. I think even Sir Ian Blair, with whom I disagree about just about everything, agrees with me about that, as does Ken MacDonald. But in the end, you know, it's the hard graft and the specialist expertise of police and prosecutors. A lot of these measures, not all of them, you know, a lot of these measures were more about politics, in my view, than they really were about serious crime fighting.
Hi, Dimitrios Giannopoulos from Brunello School, a lecturer there of criminal law and evidence. First of all, the example of interceptions that you mentioned, it directly made me think about whether the Home Office is actually undertaking any comparative law research. Because we know very well that the majority of foreign legal systems actually use legal intercepts. So I wonder, you know, what your experience is you could tell us in that respect. And the second point, I mean, you gave us a host of very interesting examples of excessive legislation, of misdirected legislation, examples of blatant departure from the rule of law and fundamental human rights. And I wonder whether you would actually agree that post 9/11, all these are illustrations of a new model of criminal procedure, of a sui generis model of criminal procedure, I would say, that is fundamentally different to the traditional approach that is security-centered and that is really takes us away from the human rights-centered approach to criminal process values.
Thank you. Okay, two very interesting questions. Comparative legal research. In my experience at the Home Office, it wasn't something that was routinely done. And I think that when it was done, it was probably defensively in response to, you know, and that's certainly been my response of the Home Office from the outside at Liberty. The best example, we at Liberty have on many occasions gone out and sought help from colleagues, lawyers or academics around the world in order to make our case. Because when we're saying, hang on a minute, not only do we think this legislation is wrong, we actually don't think it's necessary, we don't think it's proportionate, isn't there another way of cracking this? A very good way of addressing that is, of course, to look at what practices elsewhere in the world. And I suppose that the best example of us doing that was on 42 Days again, when we were a bit tired of hearing Syrian and others say, oh, but in France and Germany and other European countries, people get locked up for years without charge. And you'd sit there and you'd think, that can't be true. That just can't be true, because we would hear about it. There'd be, the United Kingdom had previously been impugned in the Court of Human Rights in the context of the Northern Irish Troubles for holding people for sort of 10, 14 days. So how could it be possible that in France and Germany people were routinely being held for years without charge? It just wasn't true. But obviously I'm not a French lawyer, my colleagues aren't German lawyers, so we commissioned help. And we went to lawyers and academics around the world. Now, of course, what was being played on here was the different legal systems. And of course it's very easy with common law systems to say what the moment of charge is, okay? But if you're not qualified, in a continental system, then you can, we were being blinded with science. And so what we did was we wrote a brief and we explained in as neutral a fashion as we could what the moment of charge means in the English legal system. What flows in legal terms, what happens when you're charged, what you are told, what consequences flow, etc., etc. What it's like pre-charge, what the charge means, what happens post-charge. And we sent that brief to lawyers and academics who were qualified in a number of jurisdictions all over the world. And we got back the results, and the results were astounding. We were told about wicked continental Europe, and the average in France and Germany was something like 5 days.
not the years, which of course were pre-trial, just like, that's what the years was, but it was being deliberately used. And what was wonderful about that piece of researcher's campaign is it was not only that it helped in the kind of legal reasoning and argument with parliamentarians, but it made a great billboard as well. So the iconic image of that campaign at Liberty was a simple bar chart that showed comparative periods of pre-charge detention around the world, with Britain 28, proposed 42, and the United States, it might have Guantanamo completely outside the legal system, but within the legal system it was something like 3 days or something, and that bar chart really got up the government's nose. And they immediately asked for the research, and we sent it, and they would say, this is all rubbish. They're not comparing like with like, they're comparing England and France is like comparing, apples with bananas or something. But do you know what? They never produced their alternative bar chart. They never produced the counter document that said, no, you say it's 5 days in wherever, we say it's 500 days. Because if they did, they'd have all the ambassadors of all these friendly countries on David Miliband's doorstep the next day, because it just wasn't true. So I do agree with you that there's great benefit, I would say, both to governments and to campaigners in just looking up occasionally and having a little look around the world, And then the second point was about, forgive me, remind me.
The sui generis criminal procedure system, something
that
is very different.
Is it 9/11? Yeah, you were kind of saying, did 9/11 do it? I'm not so sure. And if you go back to some of my examples, some of them go further back. The ASBO, the lovely innocent ASBO, is from the Crime and Disorder Act of 1998. Now, of course, the control order is 2005, but the basic idea that this criminal justice stuff is a bit tedious, and what we need is something a bit more instant. Is something that and it was a hallmark of the Blair administration, I would argue, from the beginning. But obviously, internationally and with the alliance with the United States, obviously what you have is a kind of catalyst that speeds up the chemical process after 9/11 and the war on terror. But I do think that there were trends in place before that.
One more question, please. Yes.
Yes, Robert Home from Anglia Law School. You haven't, following on from what you've just been saying about comparative law, you haven't said anything much about Europe and legislation that emanates from Europe and we have to respond to. I teach environmental law. Well, there's 200 European legal instruments in that particular chapter of the treaty, with vast potential for intruding on private life, how you throw your domestic waste away, and things like that.
Yeah.
And I can't help thinking that as the war against terror gets a bit old, the next big issue around the corner is climate change, responding to environmental crisis. Just invite your comments.
Well, you're right. I mean, you're just generally right. You're certainly right that I didn't talk much about European legislation, partly because it's a kind of personal historical weakness of mine. And you can see why. Trained in the Home Office and then going to Liberty, so traditionally not worrying about all that kind of fishing regulation stuff. But of course, we need to start worrying pretty fast. And of course, we have started worrying, and because increasingly we are finding it. So what I'm saying is, it's a professional deficiency on my part in terms of my comfort with the various treaties and all those letters and numbers that scare me. But you've found the weak spot. But equally, we have become increasingly concerned, and in particular about policy laundering, whereby our government wants to do something really quite intrusive, like, keeping people's phone calls and emails for 2 years or something, and doesn't actually want to take it to the British public or to the UK Parliament. And so what you do is you go to the Council of Ministers, you stitch it all up at the Council of Ministers, and then you come back to Britain and say, oh, it wasn't us, it was Europe. And we now need to do X, Y, Z and the other because of Europe. And I don't know whether other governments do it to the same extent, but actually that nice Mr. Clarke, who was a very mild-mannered Home Secretary in some respects, and certainly compared to Dr. Reid, he was quite good at that policy laundering stuff in Europe. And I suppose, you know, the Euro arrest warrant is something that's a really quite substantial concern to us at Liberty, because, you know, we think it needs to be at least renegotiated, because it does allow, it creates this idea that people can literally be parcelled off from one part of Europe to another without so much as a buy or leave. It's just going to be the equivalent of being taken from, you know, London to Liverpool to stand trial there, and I'm afraid that does not reflect the reality of human existence. Well, even if you're going to get a complete Rolls-Royce fair trial elsewhere in Europe or in the world, you know, to be taken from your family and your friends and your local environment, maybe your language and your legal system, to somewhere different, is going to feel like punishment in itself. And we just think that there ought to be a prima facie case in a local court, and if it's more appropriate to try you here, you should be.
Now, just by way of a comment, last question that isn't there a difference between matters relating to the environment, for instance, that you raised, and matters relating to personal freedom? And I mean, is there a comparison between the two?
I think sorry, I didn't address that. I think the point is a good one. There is always, if you're a government, there is always a good reason to interfere with people's rights and freedoms. My point is, you know, the terror threat was not invented, right? Government has done lots of these things with notionally perfectly laudable objectives. I just think that they have often acted because of a political need to act rather than because they were doing proper rational policy making, and often they have either missed the target, been counterproductive to the target, and you know, unnecessarily and counterproductively intruding on people's rights and freedoms. Now, if legitimate concerns about terrorism can be the trigger for that kind of response, other things can trigger that kind of response too. Swine flu. We could create a criminal offence of kissing a stranger. You know, I mean, there's always. What I'm saying is, there's always, you know, an arguably good reason to, you know, saving the planet. You know, there's always a good reason. So I think the gentleman's quite right, if I may say so, that this attention to detail and concern for rational policy making and sound legislative scrutiny is incredibly important.
Yeah. It only remains for me to, on your behalf, which I'm sure you'll allow me to do, to thank our speaker tonight for a very interesting lecture she's given us. I think perhaps looking back, the people who have sometimes accused you of being a thorn in the flesh of governments, and you, with your time at the Home Office, you served to governments of different political persuasions, and when you started there, I believe a Tory government was in power, and when you left, the Labour Party had got into power, so you saw things from both sides of the fence. So I would like to thank you on behalf of all of us for raising our horizons, you know, in terms of what we should be doing ourselves as individuals, and not just leaving it to the investigative journalists and civil liberty campaigners like yourself. Perhaps we should all be campaigners in our own little ways. So otherwise,
enjoy liberty if you want.
Yes, as I said at the beginning, I believe some of us here must be. I am myself a member of Liberty, and I have been for quite some time. So it's a good advertisement for us to be a little more vigilant for our own sakes and the sakes of our future generations, because you never know what's going to happen tomorrow. So on behalf of all of us, I'd like to thank you very much again for coming, and if we can show our appreciation in the